Welcome to Off the Record, a legal podcast.
Hello and welcome back to Off the Record with Rhett Burney. Rhett is a family law and estate planning attorney based in Greenville County, South Carolina, where he's helped families navigate divorce, custody, and future planning matters for more than 30 years. My name is Kevin Rosenquist, and today we've got a special guest, Bill Finn, and we're going to talk about powers of attorney. They're going to explain what they do, where they stop, and how they protect you when you can't act for yourself. Rhett, always good to see you, and Bill, it's great to meet you.
Hey, Kevin. Great to meet you.
All right, so we're talking power of attorney today. Could you explain what a power of attorney actually is for the listeners who may not know?
Yeah, I'll go first. Power of attorney is a document that allows someone to act as though they are you. You know, we can make it as broad as a client wants or as specific as a client wants, but in essence, what it does is it names someone else, if you're unable to or unwilling to, or even if you're not unwilling or unable to act, from a legal perspective. They can sign legal documents. They can open bank accounts, change beneficiaries. Can make them very broad. So it's just that document that allows there to be some type of authority given to what we call the agent to act for you.
Why do you think that everyone needs one? I think that there's probably a common misconception maybe that it's for older folks, but everyone should have one of these, right?
They should. There's a lot of situations where a power of attorney can come up, and it's not always related to old age. There's a lot of reasons someone may become incapacitated or not able to make a decision for themselves, or for some reason they can't get to the decision that they need to in the time, and there's someone else that can step in that can make that decision on behalf of them and have the legal authority to do so. So that your principal, the person signing the power of attorney, isn't someone that is going to face repercussions from not being able to make that decision.
Yeah, and to add to that, Kevin, you never know what the future holds for you, right? You could be in a car accident tomorrow, which could render you unable to take care of your affairs or to tell someone how you want your body, yourself in an incapacitated state to be treated. So if it were just limited to age, that would be easy to predict. But unfortunately, there are just events in life that we can't control where you may need that assistance from someone because of things, maybe illnesses, maybe accidents that you just can't control or can't foresee. So that's why when we counsel people, it's not uncommon for them to say, hey, I'm really not all that old. Well, we don't know when you're going to need it. So it's better to have it in place than not.
Yeah. Yeah. And so when does it kick in? When does the power of attorney kick in, and when does the authority stop?
Typically, it kicks in upon execution of the power of authority. So when you sign that document, that's granting that your named agent the power that's described in your power of attorney. It's typically valid from the time it's signed. You can have situations where there's a springing power of attorney where it becomes active upon certain conditions, but for the most part, they're effective upon when signed, and they're effective until they're revoked, whether that's either by a revocation by itself or a subsequent power of attorney that revokes any previous power of attorneys.
And we may have situations, Kevin, where you just do a limited power of attorney. For instance, in a real estate closing, it's not unusual for spouse to be here already and one spouse to have moved to where they're going or haven't moved to where they're coming to. And so we can appoint someone for the limited purpose of signing closing documents, for instance, deeds or closing settlement statements. And so once that transaction is completed, that power of attorney would no longer be valid.
All right. So you said a limited power of attorney, and then Bill, you mentioned another one. Are there other types of powers of attorney?
Sure. Yeah. So what I was mentioning was a springing power of attorney. They take an effect upon a certain condition happening. Whatever's described in that power of attorney can be a wide variety of things. If you become incapacitated or something of the like, it depends on how you draft that power of attorney. There's limited ones, like Rhett said, for situation specific scenarios, and then there's also healthcare power of attorneys. Those are designed to determine what kind of health situations you would want if you're unable to speak for yourself, whether that's life-sustaining treatment, food, tube feeding, things of those like. That's what a healthcare power of attorney would cover.
And Kevin, it's probably good for Bill and I to talk about, what happens if you do not have a power of attorney and you need one. Well, if that is the case, let's say, I'll use an example. Let's say you have an elderly person who is incompetent and they do not have a power of attorney that allows someone to make decisions for them. What we have to do in that situation is we have to file a lawsuit here in South Carolina in probate court and ask the court to, one, deem that person to be incompetent and to be in the need of someone to act on their behalf. And when that happens, when we're forced to file that lawsuit, it costs tremendous amount of money to ask permission for the court for someone to be appointed as the agent, conservator or guardian for the individual who needs it. Where if we just do the document up front, the cost is almost negligible compared to what a lawsuit costs. Because when we file those types of lawsuits, we have to bring in experts, we have to bring in medical examiners and doctors, and guardians have to be appointed, guardian ad litem have to be appointed. And so you get a lot of people in one room in the courthouse just for the sole purpose of having the court name someone, even if it's the spouse. They may just have to name that person that they've been married to for 50 years and give them the authority to make the decision for that person, their loved one. And it's a shame, but that's what happens if people are not planning in the future. And I think it's inevitable, Kevin. I always give you a hard time. You probably haven't done your will yet, have you, Kevin? Because you're trying to save the money. But
Listen, this isn't about me. All right. I don't want to make this show about me.
I know, but when you die, Kevin, I'm going to tell your wife I've got video proof that you didn't follow my directions. But people come in and they don't want to spend the extra money, but we're all living longer, right? And our minds seem to be leaving us sooner than we die. And what ultimately happens is we have to get the courts involved, and that's really not what we want to do, because when we file these lawsuits to have someone appointed, to make decisions for someone, it costs $5,000, $6,000, $7,000, $10,000 sometimes, and that's if they're not uncontested. But when we're talking about just doing a power of attorney, it costs a few $100s. Mm-hmm. And so, the payoff is huge if you do it in advance. And nobody wants to spend that money, but the alternative speaks for itself. And just the trouble, you don't get into court immediately. It's very hard to do that. So when we counsel people and talk about estate planning, this is part of the estate planning process. It's not just doing the will and the trust and all of that. It's also doing the power of attorney document. And a lot of times, people come in and they say, which document should I do? And, they're all different depending upon the circumstances. But a lot of times I'll tell them it's more important to do the power of attorney before they do the will, if they had to choose between those two documents, just because of the cost involved. And if you die without a will in South Carolina, the law tells you how your assets are going to be divided. Good to have a will or trust, but if I had to choose, I think the power of attorney is sometimes even more important and more valuable.
I think that Rhett touched on this, but another aspect of having to file a court action is that court actions take time. You're not going to answer immediately, even if you get an emergency hearing going. It takes time, and sometimes that's to the detriment of the person that needs that decision made. But until you get a court action, if you don't have a power of attorney, there's not a lot else you can do. So I think, power of attorneys are a great way to plan ahead and not only avoid that expense, but avoid any detrimental effects to someone that from the time it takes to get a court action going and to get permission to make those decisions.
Yeah, you mentioned people not wanting to spend the money on it. And, Rhett and I have talked many times about people doing stuff online through AI, what have you. I'm imagining you can probably get a power of attorney document online and do it that way as well. Can you talk about the dangers of doing that specifically for this document?
So, if you get a power of attorney online, there's different requirements and different language used state to state. You get one online, it's not necessarily going to be what's effective and enforceable in South Carolina. It may be, but it may not be. And there may be provisions of it that specifically are not enforceable in South Carolina. So it's best to go with an attorney that has done these and knows what the language needs to be in there. I know AI, makes a lot of things easier, but it also leaves a lot of open end and it leaves a lot of room for error. And I think, if you don't have someone that knows these things looking over it and making sure that this is in fact valid and enforceable in the state you're in, it can really be to your detriment in the end, and it may invalidate the entire power of attorney.
Yeah, and the other thing to think about when we do our powers of attorney, not only our durable powers of attorney, not only do we name someone to handle your finances, but we also name conservators and guardians. Those are people that are over your money and over your body when you're not capable of making decisions for yourself. And so we see people come in all the time with these documents they downloaded off the internet. They're not witnessed properly. They don't have all the information in there that's needed. We see them come in with the AI documents, and people make the assumption that it's going to be what they need in order to help them in the future if that document is something they need to rely upon. And jokingly, I think I did a blog one time that said, please download your powers of attorney and will and all that from the internet and do it, because we make a lot more money on the back end trying to fix those problems. And it just amazes me. I understand where people are coming from, but it amazes me that they absolutely risk their life's savings and assets and the relationship between their family members when they don't have the proper documents. And sure, you can go do all of that for free, but when you come to a lawyer, you're paying for that lawyer's advice. And when you download that document, I'll maybe asking a few questions, but there's a lot more involved when we do estate planning, because we want to know the family dynamics. We want to know what your assets look like, what else is out there, because not every single thing that you download from the internet or using AI is going to be applicable to your situation, and we tailor it for that. We don't just draft a document and we're done with it. We sit down and we have a conversation with you and bring up other things that you may not be aware of, or other concerns that we have that you just can't download in a form. And so when people do that, really running a risk of putting themselves in peril. Like I said, hey, go do it, because we make more money on the back end of it. But if you're really concerned about accomplishing what a power of attorney does for you, then sit down with a lawyer, because they're not that expensive when you think about what's at risk.
Yeah, and I think the DIY mentality is great in a lot of ways. I mean, we all go and do our own reconnaissance on a lot of things, but you and I have talked about this before, Rhett. Like, I don't do my taxes. I don't, I want professionals to help do that stuff, and I think, people often will try to save that money on the front end, and especially, I mean, you look at those websites and they tell you what you want to hear, right? They tell you that everything's gonna be great, we got you covered, and then all of a sudden you're not.
Yeah. And it's not unusual for people to come back and they say, hey, the situation's changed. Can we change this? Or what do you think? You download it off the internet and go to those websites. They don't give you that feedback. They really don't
Right.
care. You come knock on my door 7 days a week, I'm going to answer it, but you're not going to be able to find that person who may have made a program that you simply downloaded off the internet to print any of that stuff. And so
Hmm.
you don't know what you don't know. And even the documents that we prepare for you, as a layman, you're not going to completely understand the effect of what that document says or what those words mean. Much like your doctor, he can explain the surgery to you all you want to, but you're not going to go do it yourself, and you're not going to
Hmm.
completely understand it. And so we deal with this every single day. And yeah, I understand the do-it-yourself mentality. I've tried that myself, and it usually costs me more money
All
than
right.
the expert. Just ask my wife. But yeah,
Yep.
it's worth the sit down to talk to a lawyer and just go over your situation.
Absolutely. Yeah. I recently put a floor in my kitchen, and long story short, a professional came and put it in yesterday. So
Great.
it didn't go that well. So I'm with you. I'm with you. So once someone signs the power of attorney, do they need to take additional steps to make sure that banks, doctors, family members can recognize it and understand it?
It's a good idea to have those banks, doctors, and the commonly used ones to have a copy of that. That way, if your agent does need to act on it, they don't necessarily need to have that copy with them in order to do so. I would suggest that, their most commonly used ones, the banks, their main doctors, things like that, and that agent should always have a copy with them too, or in a safe space that they can get to, just in case they need to use it. But generally, your commonly used places, the doctors, banks, any kind of financial planning, accountants, things like that. They're good people to have a copy of that power of attorney with.
And then the other step that we add to it is we record them at the courthouse in the clerk's office and in the register of deeds or the clerk's office, because that puts the world on notice that it's a valid document.
Mm-hmm.
And so, we deal with so many different states and so many different banks and their requirements. And, we're trained at this point in time because we're dealing with banks in California and New York and so forth. And they have different requirements. In South Carolina, you don't need an actual seal for the notary, but in California you do. And so we've got to make sure all that's done. And then we learned that the hard way. But as more and more people move in and out of South Carolina, then we've learned what needs to be done. So we do record those. And if someone moves in from another state, they need to redo their power of attorney. We don't need a Minnesota power of attorney here in South Carolina. We just need to redo it because, again, it's got to be recorded in South Carolina. It may not have been executed or even have the right terminology or the statutory language that we need for it to be valid in South Carolina. So if someone's watching this video and they've moved here from a different state and they have a power of attorney in a different state, they need to redo it. If they've done theirs in our state, they've moved elsewhere, they need to redo it because there's nothing worse than needing the document only to find out that the state doesn't recognize it as being valid because it wasn't properly done in the first place.
Mm-hmm. Yeah, that's a info that I wouldn't have known. That you have to get it redone in another state, and I don't think most people would unless you talk to an attorney or know somebody who has done that. Do you find that people struggle to pick the person that they're the agent? I mean, because that's a big decision, obviously.
Yeah, absolutely. It's arguably the most important decision. People do struggle with that, and for a valid reason. Really, it needs to be someone that you have full and complete trust in. A lot of the times that's your spouse. Sometimes it's children or other relatives, close friends. But it is probably the hardest decision in doing a power of attorney is who do I trust the most to effectuate this in the way I intended to do. That's really a situation-specific person, and there's no one-size-fits-all answer to that. But it needs to be someone that you have full and complete trust in and someone that you trust will abide by your wishes and what you want and what's allowed under that power of attorney. Oftentimes, we also, we pretty much always recommend a successor agent as well. You never know what's going to happen in life. And that first agent, something may happen to them and they can't act as a power of attorney when it comes time to do so. So you need to have a successor in there too. And, that makes the decision a little more complicated and difficult to get two people, much less one that you trust. Yeah. But it is a great idea because you just never know what direction life's going to take. And if that first agent can't act, you're back to square one.
And Kevin, we have those situations where, the 85-year-old man shows up with the 25-year-old woman that happens to be a friend, and she's wanting him to name her as the agent through his power of attorney. And, that's one of the benefits of a lawyer. We look at that situation and, we'll decline that, right? Because that just doesn't look right. And I've had those occasions where I've had lawyers call me saying, hey, I've got Mr. Smith here. He said he came to your office and you wouldn't do this for him. Why not? Well, Mr. Smith brought in this 25-year-old girlfriend that he met at the bar, and I could tell right away that she was taking advantage of him. So, that's another thing that the internet won't help you with, right? It's not going to look at the situation. And you never want to name someone as your agent in your power of attorney if you can't trust them with the keys to your house or all of your credit card information or bank account information, because when you sign that document, it gives that person the authority to do everything that you do. Open bank accounts and take money out of bank accounts. So if you don't trust that person, then don't even name them as your agent.
Mm-hmm. Yeah, that makes sense. Now I'm going through a Rolodex of my people and going, oh, nope, maybe, nope. All right, well, that's it for today's episode of Off the Record with Rhett Burney and special guest Bill Finn. If you'd like to learn more about how they serve families across upstate South Carolina, visit rhettburney.com. Thanks for listening. Don't forget to subscribe and review and like and all the stuff. We really appreciate it. Rhett, Bill, thanks so much for your time.
Take care, Kevin. Good to see you.
Thank you, Kevin.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.